Everyone can be seated.
Good morning again, Doctor. Doctor, there has been testimony by yourself earlier today regarding alcohol abuse of Ms. Schenecker at the time of the incident as being some sort of contributing factor to this incident, correct?
I don't think that was I know I referenced alcohol abuse. It was in a very specific context, and I don't believe I said that alcohol contributed acutely to these murders.
Well, I wasn't sure. In fact, that's what I'm going to ask you about. Sir, isn't it true that there can be no real determination as to whether or not alcohol or alcohol abuse could have been a real contributor to this incident?
Do you mean alcohol abuse is part of Ms. Schenecker and who she was and how she was functioning? If you're talking about whether alcohol was affecting her behavior on the night of the murders, all we know is that she told us that she had not used alcohol until after the children were shot.
Okay. Dr. Otto, I want to draw your attention to your interviews with Ms. Schenecker to finish my questions this morning, if possible, just to kind of direct you where I'm going. At some point, Ms. Schenecker told you, did she not, that on January the 22nd, 2011, she woke up with a very clear thought, which is, I'm going to kill myself today.
That's exactly what she said, yes.
And that was, as we discussed earlier in your testimony, a thought that she had had a number of times over the years before, correct?
That's what she reported. I have no reason to doubt that, yes.
And isn't it true, sir, that one of the reasons, or a significant reason, let's start with one of the reasons, that she never attempted suicide in the past was because of the children and how it might affect them?
That's what she offered, yes.
Isn't it true, sir, that she actually expressed concern to you about how they might take it? In other words, how it might affect them if she had done that?
She talked about the negative effects of a parent committing suicide on children, including her own.
January 22nd comes around, 2011, she gets this clear thought that she wants to kill herself. And she goes to a pawn shop, correct? Isn't that the information you got?
That's what she told me, yes.
In fact, it was a pawn shop somewhere on Fowler or somewhere like that, close by where she lives. But they didn't have any guns, right?
That's what she told me.
So she gets directed by somebody that works at the pawn shop and says, hey, I know where you can go get a gun. And they direct her to this place that she had never heard of before, correct?
That's what she told me.
And she goes ahead, and if I'm not mistaken, isn't it true, sir, that she told you she not only didn't know where it was, but she just entered the address into her GPS and kind of went there, correct?
She said that's how she got there, right.
So she gets there, and she takes the steps to purchase a firearm from that location, and finds out she has to wait for a few days. Isn't that correct?
That's correct.
In terms of making the purchase of the firearm, isn't it true, sir, that she told you she didn't have any particular firearm in mind? She just bought the cheapest one that was available to her, correct?
Yeah, she had no preferences to the particular weapon, right? That's what she said.
In terms of the actual event of January 27th, 2011, isn't it true, sir, that she told you that she was still at that time planning to do the laundry for the children?
She said as she exited the house with Beau, she thought, oh, I need to make sure his soccer uniforms are clean for some upcoming game or whatever, yeah.
So it's the 27th, it's Thursday, the day that those children's lives are going to be taken. And she's in the process of taking Beau to soccer practice, and she's at that point still thinking about doing the laundry for the children. Is that correct?
That's what she said, yes.
Isn't it true, sir, that she told you very clearly that she saw her role in life as one of protecting her children?
Yes.
In fact, she said she was going to protect them. Isn't that true?
Yes.
In fact, she also said she had to save them. Isn't that true?
I don't remember save them, but maybe my memory is failing me, but I don't remember her saying she had to save her children. But,
She certainly had every intention to protect them to the best of her ability, correct?
oh, yes.
Despite the reasons that you were there to interview her and what has happened January 27, 2011. That was what she told you as far as what she saw her role as a mother for her children, correct?
Yes.
In fact, even after shooting Calyx, didn't she tell you that she tried to manipulate her mouth so that it would look like a smile?
She said that.
And she indicated to you that she put Calyx in her bed and kissed her and hugged her?
Yes.
And after shooting Beau, she couldn't get him out of the van, and so she had to leave him there, but she put a blanket around him and kissed him too, right?
That's what she reported, and my understanding is that's how he was found, with a blanket.
Your position, sir, is it not that when she woke up on January the 22nd and said, I'm going to go kill myself, I'm going to go get a gun and kill myself today, it's your impression, sir, is it not, that she should have been hospitalized then? Is that correct?
Certainly. If she has mental illness, which she does, and she's in the process of procuring a weapon, she should be in the hospital, whether voluntarily or involuntarily, without a doubt.
And certainly when she actually made the purchase of the gun, she should have been in the hospital, correct?
Then too.
Any measure of Ms. Schenecker's state of mind at the time of the event would, by necessity, have to include an understanding and acceptance of the fact that she was a severely mentally ill woman, correct?
At the time of the offenses, yes.
Doctor, isn't it true that Ms. Schenecker told you that her children were still in her heart when you interviewed her?
I don't remember if she used those exact terms, but she talked about loving them and feeling connected with them and regretting what she did. So essentially she said that. I don't know if she used that word literally.
Doctor, in terms of an understanding of whether or not Ms. Schenecker understood that what she was doing was wrong, isn't it fair to say that those instances in which you made inferences that possibly could have indicated that she did know that what she did was wrong, isn't it correct or accurate to say that those inferences could have gone the other direction as well, and it could be possible that she did not know that what she did was wrong?
I don't deny, I can't say it's impossible that I can't say that it's impossible that she didn't know what she was doing was wrong. I can't give you that level of certainty to my opinion. So I agree with what you're saying.
Judge, I have no other questions.
Redirect. Now, Doctor, the defense asked you a lot of questions about, is it possible, is this possible, is this possible, is this possible? And you basically conceded that many things are possible. Is that accurate?
Yes.
Okay. Now, to what standard of certainty do you hold the opinion that the defendant was sane when she murdered her children?
I would say I'm convinced in my opinions. I don't think this is a close call. Sometimes we're asked to use language about reasonable psychological certainty. I would offer that level of confidence, although there is dispute as to the meaning of that. But I'm quite confident about my opinions about Ms. Schenecker's mental state at and around the time of the offenses. However, there are many things that I cannot rule out to complete impossibility.
Okay. And why do you feel so confident about your opinion?
Because I think there's data coming in from every which way that supports my opinion. what she wrote in her journal, what she said to the officers on the scene, what she said to the officers who interrogated her, what she said to jail mental health staff, what she said to in the presence of Dr. Solomon and her attorney when she was video recorded, when asked about what she had done and why. So in my opinion, I look at all those data and I form the opinions that despite the fact that she was experiencing symptoms of severe and persistent mental illness at the time of the offenses, she did know that she was killing her children, that she had killed her children, and she did know that that was wrong.
Okay, you referenced what she told jail personnel or jail mental health clinicians. Do you recall what it was that she told them that makes you think that the defendant was saying at the time of the offense?
She reported to jail medical staff that she had shot her children the day or two preceding.
Okay. So when you concede that certain things are possible, that is not an expression that you doubt your opinions. Is that accurate?
No, other than my opinions aren't 100% certain. They are not. At least those opinions are not 100% certain. I'm 100% certain she has severe and persistent mental illness. I'm 100% certain that she had a problem with alcohol abuse and the pain medications. 100% certain of that. Some of these other issues I'm less certain, but reasonably certain that I offer these opinions.
Okay. And you indicated that on January 22nd, when the defendant woke up and indicated that today was the day she wanted to kill herself, that she should be hospitalized. Would that be pursuant to a Baker Act?
That's only one way. She could have driven herself to the hospital. Okay. A Baker Act in Florida refers to being involuntarily hospitalized. You can go on your own and say, I'm thinking about killing myself, or I'm thinking about killing other people. I just bought a gun. You'll get in the hospital. Not involuntarily.
Okay. And even though you feel that maybe she should have been hospitalized that day, do you still believe and opine that she still retained the ability to know right from wrong?
Yes.
And why do you feel that way? Or why do you have that opinion?
Judge, can we approach?
Yes.
Doctor, you can go ahead and answer the question.
Can you repeat the question?
Basically, you indicated that you felt that she should be hospitalized, but that she also retained the ability to know right from wrong.
Yes.
Why do you opine that?
A number of factors, including that she shared with Dr. Solomon and her attorney that she didn't tell anyone about her plan because she thought it would be thwarted. I infer from that knowledge of wrongfulness. Again, that she had developed a plan whereby she would kill one child first and then the next. I infer from that knowledge of wrongfulness. Her descriptions of what she done as being horrible and the worst thing she ever did in her life, from that I infer knowledge of wrongfulness.
Thank you, Doctor.
May this witness be excused?
Yes, Judge.
Yes, Judge. Sir, you may step down and you're free to go.
Thank you.
Counsel will let you step up. state my colleagues next witness.
Dr. Donald Taylor.
Thank you. Good morning, sir.
Good morning.
Please state your name for the record and spell your last name for the court reporter.
Donald R. Taylor, Jr., Taylor.
Sir, what is your profession or occupation?
I'm a physician specializing in forensic psychiatry.
Dr. Taylor, could you tell the jury, please, your training, education, and experience that leads you to hold the occupation, the profession you have presently, with an emphasis on describing your experience in forensic psychiatry?
I graduated from the University of South Florida with a bachelor's degree in 1979. I attended medical school at the University of South Florida College of Medicine and received a medical degree in 1984. I attended residency training in psychiatry at the University of Florida, which I completed in 1988. I then completed a one-year fellowship in forensic psychiatry at the University of Florida, which I completed in 1989. Since 1989, I've been in private practice in Tampa, specializing in forensic psychiatry. I have been licensed to practice medicine in Florida since 1985. I became a diplomate of the American Board of Psychiatry and Neurology and Psychiatry, which is also called board certified, in 1990. Since then, I've performed somewhere between 4,000 and 5,000 evaluations on defendants in the criminal court system.
You indicated that you had a fellowship in forensic psychiatry at the University of South Florida?
At the University of Florida.
I'm sorry. Okay, University of Florida. Could you describe for the jury, please, what a fellowship involves?
Once you complete a general psychiatry residency, if you have a subspecialty within psychiatry that you would like to pursue, there are fellowship programs available. There's fellowship programs in child psychiatry, there are fellowship programs in geriatric psychiatry, and I had an interest in forensic psychiatry, so I did an additional one-year fellowship in which I was trained in performing forensic psychiatric evaluations, which include both criminal court evaluations and evaluations on individuals in civil court cases, plus got some didactic training in mental health case law and things like that.
Does a fellowship in a specific field of psychiatry involve essentially focused training and experience and education in that one field?
Yes, during the time of the fellowship.
Doctor, have you also had a clinical practice?
Yes, I have.
And what was is the nature of your clinical practice?
From 1989 until 2008, I combined the forensic psychiatry practice with a clinical practice in which I had an office-based practice. I saw outpatients, treating them for a variety of psychiatric conditions, whether psychotic conditions such as schizophrenia, mood disorders such as bipolar disorder, major depressive disorder. I also did hospital consultations during that time, and if somebody needed to be psychiatrically admitted to a hospital, I had admitting privileges at the University of South Florida Psychiatry Center as well as St. Joseph's Hospital. I gave up the inpatient part of the practice sometime in the late 1990s, and in 2008 I gave up the clinical part of the practice, and since then I've focused exclusively on forensic psychiatry.
Doctor, can you give the jury an idea of what forensic psychiatry involves as it is distinct from general psychiatry?
Forensic psychiatry refers to the interface between psychiatry and the law, as opposed to clinical psychiatry, where somebody is coming to you to receive treatment for their mental condition. In conducting a forensic psychiatry evaluation, it is usually for some type of legal purpose. The person is either in the criminal court system, or they may be in the civil court system as a result of a personal injury case or a workers' compensation claim, and you're doing an evaluation on that individual for the purpose of making a diagnosis and also answering some medico-legal question or rendering an opinion regarding how their diagnosis fits into whatever legal issue is relevant at the time. You may or may not make treatment recommendations as part of the evaluation, but you don't usually provide the treatment yourself.
And you have been practicing forensic psychiatry since what year, sir?
Since 1989.
And since that time, how many occasions have you been allowed in courts of law to express your expert opinion on issues within the field of forensic psychiatry?
I have records going back to 1997. So in the last 17 years, I've testified as an expert in court system in hearings 113 times, trials 29 times, and sentencing hearings 24 times. So that's a total of 166 times that I've been allowed as an expert to testify in court, 29 of which were trials.
And that's just since 1997. It doesn't cover the first 8 years of your practice?
Correct. There was some additional cases the first 8 years of my practice.
Okay, sir. Other than Hillsborough, were there other jurisdictions in which you were authorized, or excuse me, permitted to express an opinion as an expert on the field of forensic psychiatry?
Yes, I've also testified in the 6th Judicial Circuit, which includes Pasco and Pinellas counties. I've testified in the southwest end of Florida in Lee County, which is Fort Myers. I've testified in Alachua County, which is Gainesville. I've testified in, I forget the name of the county, I believe it's Bay County up in Panama City. So there's been probably 8 or 10 other counties or court jurisdictions other than Hillsborough in which I've testified over the past 25 years.
Thank you. Your Honor, I'd tender Dr. Taylor for questioning as to his qualifications.
No questions.
You may continue.
Thank you. Doctor, in your capacity as a practicing forensic psychiatrist, did you become involved in the case of State of Florida versus Julie Schenecker?
Yes, I did.
And have you been retained by the State of Florida through the Office of the State Attorney, in the person of me, to assist the prosecution in forming or evaluating this case on state of mind and mental health issues?
Yes, I received a letter from the state attorney in this case. I believe it was in February of 2011, about a week or 10 days after the shooting happened, asking if I would be...
Objection, hearsay.
That's the exact question. Go ahead.
I was retained for the purpose of conducting a psychiatric evaluation for the purpose of rendering an opinion regarding her mental state at the time.
And like other practitioners in forensic psychiatry, are you compensated for your work on this case as you would any other work you perform in the field?
Yes.
Have you, well, let me ask you some general questions first before we get into the particulars of this case, sir. Can you describe and explain to the jury the process or procedures you employ when you're tasked with trying to form an opinion of a person's state of mind at the time of the criminal offense at a date sometime after the criminal offense? What do you go about doing, in other words?
In general, obviously at some point you're going to evaluate the individual, the defendant. You may be asked to evaluate them shortly after the alleged offense, or it may be sometime later. Both prior to and after evaluating them, you gather as much relevant material as you deem necessary to support an opinion and conduct a complete evaluation in the case. It can include previous records of medical and or mental health treatment. It includes things such as police reports, reports from the medical examiner's office, things such as that. It includes reviewing transcripts of depositions of other witnesses in the case, some of whom may be fact witnesses, some of whom may be law enforcement witnesses, some of whom may be other experts who have evaluated her. And after reviewing that material and then evaluating the defendant in an individual interview, eventually you reach a diagnosis and an opinion on the relevant issue and usually produce a written report containing those findings.
Thank you, sir. And is that the general procedure that you followed in this case in arriving at your opinions that we're about to hear shortly?
Yes.
Okay. Can you give the jury, please, an overview or summary of the information, the collateral data that you received and considered in your work in this case?
The primary collateral data in this case, first of all, consisted of records of the defendant's treatment when she was a military dependent. That started about 1993 and continued up until the time she was arrested in January 2011. There were also additional records from other places where she'd received medical or mental health treatment. It included the admission to the National Institute of Health research protocol for treatment of depression from 2001 to 2002. It included the record she had of outpatient treatment at the University of South Florida Department of Psychiatry, which began in September 2007 and continued until January 2011. It included the records of the treatment she had in the dual diagnosis program at Winmore Hospital, which, if I recall, was for about somewhere in the area of 15 to 18 days in November 2010. Those were the primary medical and mental health records that I reviewed prior to her incarceration. Additional records included the police reports, the reports of the medical examiner's office. There were several photographs of the case which were forwarded to me for my review. There were, as I said, transcript of depositions of lay witnesses in the case, several police officers. I also reviewed transcripts of depositions of 3 mental health experts who had evaluated her for the defense. That was Dr. Kropp, Dr. Mayer, and Dr. Solomon. As part of the police reports, they contained journal entries, which were about 16 pages, that she had made starting about 5 days prior to the alleged offense and continuing until shortly after the alleged offenses occurred. Also in there were copies of email and texts that had been sent either by the defendant or by her husband, and some of those were emails back and forth with family members or friends. So that was the primary records of prior to her incarceration. Starting with she was incarcerated, I reviewed her records of medical and mental health treatment at the Hillsborough County Jail, which again began with January 28, 2011, and was through the time one of the times that I evaluated her at the jail last year. I believe it was around May or June 2013 that I last reviewed the jail medical records. Also included in there was the records of her admission to Tampa General Hospital, which happened shortly after she was arrested. After she was arrested, she was evaluated by medical staff at the jail, and this was the evening of January 28, some critical laboratory values came back indicating that there was a medical emergency related to an overdose, so she was transferred to Tampa General Hospital for an emergency admission, and she remained in Tampa General Hospital for 2 days and returned to the jail the following Sunday. So I reviewed the records of her treatment at Tampa General Hospital for those 2 days while she was there. I also...
Let me interrupt you for just a second, sir.
Sure.
The test results from Tampa General Hospital indicated an overdose of what substances?
Well, she had a toxic level of lithium, which was one of the psychotropic medications she was taking. She also had prolonged bleeding times, which suggested that she also had a toxic level of Coumadin, which is an anticoagulant medication often referred to as a blood thinner, that she was also had been prescribed, but on that evening had taken an excessive amount. Her urine drug screen was also positive for opioid analgesics, which would have been reflecting the oxycodone and the hydrocodone that she had reportedly taken, as well as benzodiazepines, which would have reflected the Klonopin that she had reportedly taken, which was a prescribed medication for her at the time. So there was physical evidence that she had taken unknown quantities of at least those 4 medications, and it's possible that there could have been others.
Okay, Doctor, I interrupted you. You were continuing with your description of all of the sources of information and collateral data you had reviewed. Please continue if you had not completed it.
Well, in addition to reviewing written records, I listened to the transcript of her interview by Tampa Police Department detectives, which occurred around noon on January 28 of 2011. I also reviewed a transcript of that interview in addition to listening to the audio recording. I also reviewed a audio-video recording of an interview Dr. Solomon conducted on her while she was in Tampa General Hospital. That would have occurred on Saturday, January 29. Once she was, and I already mentioned that I also reviewed the records from the Hillsborough County Jail. And finally, I interviewed her on 5 different occasions between March and June 2013 for a total of 13 hours.
When you interviewed the defendant on those occasions, can you describe for the jury how you would have introduced yourself and how you would have explained to the defendant your role in the case and the reason for your appearance with her?
Well, first I asked her what was her understanding of who I was and the reason that I was there to see her. And I don't recall whether her answer was complete. I do recall that she had a general understanding of what it was. And to clear up any misunderstanding, I made clear that I had been retained by the Office of the State Attorney to do a psychiatric evaluation, that I had been reviewing records and would probably review additional records, and that I would interview her as many times and for as long as I felt it would take to obtain the necessary information in order to form an opinion in this case, which was regarding what her mental state was at the time of the alleged offenses. I told her that I would, at the end of the entire evaluation, including the records review, prepare a written report, which would be forwarded to the Office of the State Attorney, that her attorneys would be given access to my written report, that if I was listed as a witness for the case going to trial, that her attorneys would have the opportunity to depose me, to ask me questions in deposition regarding my opinion and the things that we talked about during the evaluation, and that if the case went to trial, that I may be called as a witness to testify regarding the things we had talked about during the interviews and what my opinion was. So that's to distinguish, that's a standard set of instructions for conducting a forensic psychiatric evaluation, to make clear that the person knows that this is a little bit different from a standard clinical evaluation, in which, for the most part, information that they share with you, you are going to keep private or confidential and not be sharing the information with somebody else, at least not without their consent.
In conducting such an evaluation and reviewing such collateral data as you've described, is there a certain specific source that you attribute greater significance to or place greater emphasis on than other type of collateral data, whether it be temporal or the nature of the information?
Well, it varies from case to case regarding which types of data you feel is more reliable and which you might give less weight to.
Okay. Doctor, as a result of your work in this case, have you generated a report concerning your work and your findings and opinions in this case?
Yes, I have.
And has that report been reduced to writing?
Yes.
And what was the length of your report, sir?
The report was 183 pages long,
Yes, sir.
so I don't know that reduced would be the right word for it,
Okay.
but it was put into writing.
Well, we're not going to go through page by page, Doctor, but
Thank you.
as a result of your work on this case and your review of the records and interviews of the defendant, have you reached an opinion on the issue of whether the defendant at the time of the offense was legally sane or insane, as those terms are used within the state of Florida?
Yes, I did.
Okay. Would you explain to the jury, please, what your understanding is concerning what the legal standard for sanity is, or excuse me, legal standard for insanity is within the state of Florida in the courts of law?
The legal standard in Florida is that, for insanity, is that the individual suffers from a mental infirmity, disease, or defect, which either prevents them from knowing what they are doing or the consequences of what they are doing, or if they know what they are doing and the consequences, they do not know what they are doing is wrong.
Okay, sir. The opinions that you're about to testify to what level or degree of certainty do you hold those opinions?
My opinions have been stated within a reasonable degree of medical certainty.
Is that the standard degree of certainty within the field of forensic psychiatry?
Yes, it is. If you're not able to arrive at an opinion within a reasonable degree of medical certainty, the correct response would be to say, I do not have an opinion, or I have no opinion.
Okay, sir. Let's take your opinion, if we may. First, in general, what is your opinion in general as to whether the defendant at the time of the murders of Calix and Beau Schenecker was legally sane or insane, as those terms are used in the courts of law of Florida? And then we'll go into this step-by-step analysis.
It is my opinion that in both cases, she was legally sane at the time of the alleged offenses.
Let us address then, if we may, your opinions with regard to each of the elements of the issue of insanity within the courts of Florida. What is the threshold issue as you understand it? The threshold question to be determined before you get on to the questions of whether the person knew what was going on, knew the legal consequences.
Well, the first threshold is at the time, were they suffering from a mental infirmity, disease, or defect?
And what is your opinion in that regard?
It is my opinion that she did. It is my opinion that she met criteria for a type of bipolar disorder, and that at the time of the alleged offenses, she was experiencing a major depressive episode.
Okay, sir. And did your review of the records reveal that this defendant had been diagnosed with bipolar disorder for an extended period of time of her life?
Yes, she had.
Okay. And is your opinion then consistent in most regards with those previous diagnoses?
Yes, it was. She had been diagnosed with one type or another of bipolar disorder since at least 2001. And my opinion is that that diagnosis is correct.
Do you have an opinion as to whether at the time of these offenses this defendant knew what she was doing or knew the consequences of her acts?
Yes, it is my opinion that she knew what she was doing and she knew the consequences of what she was doing.
Can you point and describe to the jury what information, what collateral data, or what information provided by the defendant you have considered that in your view supports your opinion on that, well, one issue as to whether the defendant knew what she was doing or knew the consequences?
Regarding that issue, as well as other issues involved in this case, it's important to understand that it can be difficult to look back after 2 or 3 years and attempt to arrive at an opinion within a reasonable degree of medical certainty what somebody's mental state was at that point in time. In that case, you are relying not only on what the individual tells you once you have the opportunity to interview them, but you want to be able to review as much collateral information as is possible. In this case, there was an unusual opportunity to review collateral information which contained a significant amount of information regarding her thoughts and feelings about what she was doing at the time, specifically the journal entries that she made, which, as I said, started about 5 days prior to the alleged offenses and then continued for some brief period of time after the alleged offenses. So I gave great weight to the journal entries that she made at the time. Those entries were consistent with some additional statements she made on Friday to the Tampa Police Department detectives who interviewed her, to some of the jail medical staff that provided services to her on Friday evening, and then during her interview with Dr. Solomon, which at Tampa General Hospital the following Saturday. And again, the statements that she made during that time were generally consistent with each other, and they were also consistent with the physical evidence in the case. So again, I gave great weight to those. In terms specifically that she had knowledge of the nature, or that she had knowledge that she knew what she was doing and she knew the consequences of what she was doing, there were several statements she made in the journal indicating beforehand that her intent was to kill the children, and that afterwards she was aware that she had killed the children. Specifically, she made statements in the journal stating, "I had to bring them on with me." This is prior to the alleged offenses. "God will take Beau and I to heaven." "I was planning a Saturday massacre." "Calyx, she gets it first. Now that he's turned on me, he has to come along with us."
Referring to whom?
Referring to Beau.
Thank you. Proceed, please.
And then after the alleged offenses, she made entries into the journal. "I've offed Beau on the way to practice. Offed Beau in the van going to practice. Beau and I are going to heaven. Wish heaven for Calyx too." She made statements regarding making arrangements for a memorial service. Her last, one of her last entries was, "The kids are dead in the van, Beau and Calyx in bed." Then when she was interviewed by Tampa police detectives the next day, she made similar statements such as, "I'll see you again in heaven. Beau went first. Calyx went second. I sure as hell would like to go third." At one point, she appeared to exhibit some confusion at that point regarding whether the children were alive or dead. And a detective asked her, "What do you think?" And she said, "I don't know. I hope they're dead."
I'm going to object to this one.
We'll overrule.
Later that evening, while being seen by medical staff at the Hillsborough County Jail, she made a statement that, "I want to be in heaven with my kids." When she was interviewed on Saturday by Dr. Solomon, she stated that she was going to shoot first the kids, then me. So based on the totality of this information, it is my opinion that it was clear that she was planning to use the gun to kill the children, and that immediately after she had done so, that she knew they were dead, which again in my opinion is that she knew what she was doing and she knew the consequences of what she had done, specifically used a gun to cause their death.
Okay, sir. Do you have an opinion, sir, as to whether the defendant knew at the time of the murders of Calyx Schenecker and Beau Schenecker that what she was doing was wrong?
Yes, in my opinion, she knew beforehand that what she was going to do would be considered wrong, as well as afterwards that what she had done was wrong.
Have you in any fashion in your analysis separated the issue of wrongfulness into subcategories?
Yes, I broke it down into 3 different types of knowledge of wrongfulness.
Please explain. I'm sorry.
The first being whether the individual themselves feel like they are doing or have done something wrong. The second, whether they are aware that other people in society would view their actions as wrong. And the third being a knowledge that what they were going to do or had done was against the law, and that they would face criminal sanctions as a result.
And could you describe for the jury, point to the jury, those facts, statements, or data that support, in your opinion, your views that of the defendant's ability to understand and comprehend the wrongfulness of the murders in each of those three subcategories?
Well, first of all, in terms of whether she herself believed that committing the acts were wrong, she made a journal entry in which, referring to Calix, she said, "On Saturday she called me an evil soul. The evil starts Thursday." So in my opinion, referring to what she is planning to do as evil demonstrates personal knowledge of wrongfulness. When she was being interviewed by the Tampa police detectives, she made two statements. One was a statement that this is the worst thing I've ever done in my life. The second was a statement regarding after she had indicated that she believed that Beau and Calix were in heaven and that she would join them in heaven. And then she stated, "If I get to go to heaven." So in my opinion, those statements indicate that at a personal level, she knew that what she was going to do was wrong and that what she had done was wrong.
All right, and on the second level or consideration of wrongfulness, that concerns what manner or interpretation of wrongfulness, sir?
Whether other people in society would view what she was going to do or what she had done was wrong.
And what is your opinion in that regard?
First, prior to
I'm sorry,
the
sir.
alleged
Let
offenses.
me ask you this specifically. I jumped ahead of myself. Is it your opinion that the defendant knew what she was doing would be viewed to be wrong by members of society?
Yes.
And then what information or collateral data could you point the jury to or describe to the jury as a basis for that opinion, please?
The first was the testimony by the deposition testimony by the owner of the gun shop.
Yes.
Form the basis for your opinion that the defendant at the time of the offenses knew that members of society would view her conduct, the killings, as wrong. Could you please continue?
Well, when she went to purchase the gun, she did not tell the owner of the gun shop that she intended to purchase it to kill herself and her children. Instead, she told him that she needed a gun because her husband was away from town and there had been burglaries in the neighborhood. In my opinion, that indicates that she was aware that the fact that she felt the need to give a false reason for purchasing the gun indicates that she was aware that had she given the actual reason, the gun would not have been sold to her. At some point shortly after the alleged offenses, she placed notes on the door telling carpool members or anybody else that might come to the house that they had gone to New York City for the weekend and would be back Tuesday. That indicates to me that she was aware that if anybody were to come to the house and either see what she was about to do or more likely what she had done, that they would take some kind of action at that time. when she was interviewed by Dr. Solomon 2 days after the alleged offenses, she made statements, number one, that she did not tell anyone about the plan because they would abort it somehow. She also said that had Parker not been out of town, she could have held back on the plan. So all of those put together, in my opinion, provide a basis that she knew that other people would view what she was going to do or what she had done was wrong.
Okay. I'd like to draw your attention to some of her journal entries where the defendant purportedly wrote, and I paraphrase, that she wanted to save the children from the evils of the world, perhaps molestation or perhaps bipolar disease, things of that nature. Are you familiar with those entries?
Well, I'm familiar with the journal entries, but the issues regarding rape or molestation were not contained in the journal entries.
Okay.
She expressed concern about them, but not about rape or molestation in the journal entries.
All right. Well, let me ask you your opinion in this regard. The defendant's expressions, whether in the journal entries or expressed at any other time in any other form, that her conduct was a expression of her desire or result of her desire to save or protect the children, the killing of the children. Do you have an opinion as to whether or not that rises to the level of a delusion?
In my opinion, the concern she expressed about the children did not rise to the level of delusion.
And can you explain why not, in your view?
Well, going back to the journal entries, she gave essentially two main categories of reasons why she was going to kill the children, and then afterwards why she had killed the children. One was that she did express concern that that she was passing along her DNA to them and that they might themselves develop bipolar disorder, as well as she was concerned about how the effect of living with the shame and embarrassment of a mother who had committed suicide would affect them in the future. She also made several statements in which she indicated that another part of the rationale was that they had become mouthy or sassy or otherwise disrespectful with her. Now, at no point in the journal entries or her statements to detectives or her statements to jail medical staff or at Tampa General Hospital or anybody else in the first 48 hours or so from the alleged offenses, did she make any statements that could even conceivably rise to the level of a delusion, such as the world is a scary place and if I leave here they're going to be raped or molested or something along those lines. Those statements came later. So in my opinion, the statements that she made and the rationale that she gave, in my opinion, both to justify to herself and to others the actions that she was going to take or the actions that she had taken afterwards, again, were a combination of some degree of legitimate concern for the children and some degree of acting out anger or resentment at her family.
Okay. Can you describe in general terms what psychosis is or what a psychotic state would be in general?
Psychosis or a psychotic state is a condition in which somebody has an altered perception of reality, where in some manner they lose contact with reality. It usually comes in the form of either a delusion, which is a false belief that has no basis in reality and is a result of a mental illness, or a hallucination, which can be an auditory hallucination or a visual hallucination, where somebody believes that they are either hearing or seeing something that is not actually there.
Do you have an opinion whether at the time of the offenses, the murders of Beau and Kaylee Schenecker, whether the defendant, Julie Schenecker, was psychotic or in a psychotic state at that time?
No, I've seen no evidence that she was experiencing symptoms of psychosis or was in a psychotic state at that time.
Okay. Doctor, have you expressed all of the underlying information and collateral data that supports your opinions on the ultimate on the question of sanity as you've already described it?
Well, the only other issue was, my opinion was that she was aware that what she had done would be viewed as legally
I'm sorry, we
wrong.
didn't get to that stage. You're correct. I omitted that. And what do you mean by legally wrong, sir?
That law enforcement officials would consider it against the law and she would be likely to face criminal sanctions for it.
And what information, data, or evidence do you rely upon for that opinion, sir?
It was pretty simple that in her interview with detectives, she first made a statement that I don't want to go to prison or jail. And when asked what she would like to see happen, she made a statement that she would like to pay to stay away from jail. So in my opinion, that provided evidence that she was aware that going to jail or prison was a likely outcome now that she had been detained by law enforcement.
Thank you, sir. At this time, I have no further questions. I tender the witness.
Okay, thank you. And what we're going to do now, being aware of the time, is we're going to go ahead and send the jury and everyone for their lunch break. We'll return. It's almost 12:15. Let's make it 1:30 as our return time. Again, the courtroom 53 in the usual fashion. 1:30 p.m. Give you about an hour and 15 minutes. And as I send you out for this lunch break, I'll remind our jury we're in the course of trial. The instructions apply. You're not to discuss the case among yourselves, not to discuss it with anyone else, not to allow anyone to discuss it with you in your presence. Again, if anyone attempts to say anything to you or in your presence, that's when you tell them you're on the jury trying the case. Tell them to immediately stop. If they persist, leave them at once. Tell one of the bailiffs who in turn will advise me. Once again, this case must be tried upon the evidence presented in this courtroom, in your presence, in the presence of the attorneys, the defendant, and the judge. You're not conducting an investigation on your own, not visiting the places that may have been described in the evidence, not to read or listen to any reports about the case from any source whatsoever, not to speak at all with attorneys, witnesses, or defendant about any subject until your deliberations are finished, not to do any research, gather information, or communicate about the case or the people or places involved through any means, including electronic devices. With that reminder of our instructions, we'll see you at 1:30.
All right.
Jury has exited the courtroom. Door is closed. Anything from counsel before we give you the lunch break?
Yes, can we approach on one matter?
Sure. You can all have a seat.